Hello again, everybody. This is attorney Mark Brunner. Thank you again for joining me here today on Talking Texas Law. Well, today let's talk about electronic ankle monitors. Frequently used by the court, either before trial, let's say when someone's out on bond, or post-trial if someone's on probation, or even later on parole. So let's talk about sort of what an electronic ankle monitor is, what you can expect if you are a defendant that's required to have one, and then how they are used by the court in the criminal justice system here in Texas. So what is an electronic ankle monitor? Well, it is a very robust little device about the size of a pack of cigarettes that a person wears on a strap around their lower ankle. It does not have to have contact with the skin, like what's called a scram monitor, which is a monitor that tests for alcohol. So an ankle monitor can be a little more looser fitting, but not too loose. It is a waterproof device. It is very shock proof. Tends to be something that is mechanically very sound. There would be a company that would contract with that county or that district or whoever is imposing the sentence. They are the ones that would be required to install the unit, to put it onto the offender or the suspect, to also set up what's a home monitoring system, or what's called a base, that would report in. Usually that is connected to the internet, Wi-Fi. Sometimes in the old school days it was connected to the phone lines. The monitor that the person wears reports back to that base. The base then reports back or sends a signal into the monitoring company, who then, and we can talk about this a little bit later on, then makes a report to the supervising agency, whether that's the probation department, pretrial services if the person's out on bond, etc. So again, the experience with a person who is wearing it, they've got to have this device on. It's bulky. It can be inconvenient. It doesn't really interfere with your life as much as you think it might. I know many people former clients of mine that have had ankle monitoring devices on, and it's the kind of thing where it's frankly a pain, but if that's the thing that's keeping you out of jail, or that's the thing that's keeping you from going to prison wearing this device, well, it's probably a pretty good sacrifice, a pretty good trade-off. So let's talk about kind of what the device provides to the criminal justice system. Well, again, this is for monitoring exactly where that person is, the person who has the order to have it. Let's just call them the defendant. Again, this could be a pretrial defendant, innocent until proven guilty, but perhaps as a condition of a bond, they are required to wear this device. Or post-conviction, they've been placed on deferred, they've been placed on probation, perhaps even let out on parole after they've served a jail sentence or a prison sentence, and now they've got to wear this device. What can the device do in the overall criminal justice system? Again, tell us where that person is. So pretty much at all times, this device will be pinging back to its home unit and sending a signal, and then whoever, pretrial services, prosecutor's office, sometimes even a victim, could log in and find out where that person is. When a device is installed, and later this can change, what they will set up with is what's called zones. So let's say an offender is essentially on house arrest. Well, they can very much dial in, set up what they can call electronic fence. This is where the person lives. They live on 123 Main Street. They will go on there and set up an electronic GPS boundary that the person cannot leave that area. If they leave that boundary, a ping will go out to the supervising department. These zones can be flexible like that. It doesn't have to be that restrictive. It could just be generally, we want you to wear this monitor so we know where you are, but we don't have that electronic fence for house arrest. Or it could be a little bit of both. It could say, okay, well, we're going to let you, we want to know that from this time to this time you're going to be home. So we've got the fence here. You say you work over here on, Jones Avenue, 226 Jones Avenue, and you're going to take this street to get there. Okay, so we're going to set up a time from 9 to 5. You're going to be here on 226 Jones Street on Monday through Friday. You're going to take this route to and from work on certain times back to, 123 Main Street. They can do that. They can set up those kind of flexible fences to allow you windows of time to be certain places. Additionally, they can set up, instead of zones where you're supposed to be at certain times, the probation department, the electronic monitoring company, the judge, whoever, can set up exclusionary zones. Let's say a victim of a crime wishes to say that I want my home, my place of business, my kids' schools, my spouse's place of business, I want those zones excluded, where if this offender comes within a set period of distance between here and there, I want to be notified of that. So that can be set up also as well. So again, inclusion, exclusion, either way it can happen like that. So again, a very powerful, robust device that a prosecutor, a court, pretrial services, bond company, whoever may use to supervise that person. Again, it's not just a live pinging back and forth, but in this computerized age where it's really easy to record things, storage and data is cheap. At any time, somebody can go back and say, I wonder if, on a Monday morning, they can say, well, I wonder not where the defendant is right now, but where he was last week. Let's say where he was New Year's Eve, where he was on Christmas. Was he out running the roads, the day of the Super Bowl or something like that? So you can easily go back in with a computer and log into the company that runs that monitoring service and easily call up any day of the week, any hour or whatever, and then see how that person has been complying. A very powerful tool. Sometimes even they can even with GPS figure out the elevation of somebody. I was involved in a case not that long ago where they were able to tell that a particular offender was not just standing on the edge of his backyard based on his distance of the electronic monitoring back to the home unit, but was in fact standing up on something, in fact looking over his fence. They were able to deduce that he was peering into the backyard of neighbors because of the elevation at which the signal was going back to the home unit, and that was causing some distress with some of his neighbors. And the prosecutor was able to go back, look in there, log on with the help of the company that had the electronic monitor, and show that the person wasn't just, yes, they were inside their property, but they were standing way up high on something, likely for no good reason. So again, a very powerful tool that people can use. So something to watch out for if you are in fact the person ordered to have this on you. As always, this video is being offered for educational and informational purposes only. It's not to take place of a traditional attorney-client conference, and unless you are already a contracted client of mine, I'm not your lawyer. This has been Attorney Mark Brunner, and thank you so much for joining me today on Talking Texas Law. I'll see you all next time.